Hey folks, welcome. In this video, I'm going to teach you what the difference is between a first-party special needs trust and a third-party special needs trust. So pull up your chair real close, folks, and get your pen out and your notepad, and let's learn. All right, folks, the difference between a first-party special needs trust and a third-party special needs trust, in my view, from my experience, the biggest difference is the following. A first-party special needs trust is also known as, AKA, also known as a payback trust. A payback trust to whom? The government. So when you think of first-party special needs trust, folks, think of, yes, it is protecting, sheltering assets that a special needs person may have inherited, either through their parents or grandparents, through a lawsuit or a settlement or some type of personal injury matter, or maybe somebody left them life insurance or something of that nature. And usually that person who gave the money to them, from my experience, in an inheritance setting, usually that person passed away and they did not do a proper estate plan. They either left that asset through a will or no plan at all, or maybe through beneficiary designation. I've seen that before, a big life insurance policy being left to a special needs person through a beneficiary designation or life insurance, which seemingly seems okay. Yeah, it avoids probate, but not a special needs person is on government benefits. They have to adhere to the regulations and not have assets more than usually $2,000. So what does that inheritance do to them? That's correct. It jeopardizes their government benefits, and it can easily disqualify them from government benefits as well. So what is the remedy there, folks? First-party special needs trust. In the industry, you'll hear attorneys often refer to a first-party special needs trust as a D4A trust. And now the attorney can draft, your special needs attorney or your elder law attorney can draft a proper D4A first-party special needs trust. And the person creating that special needs trust either has to be a parent, grandparent, legal guardian, but under this Special Needs Fairness Act of roughly 2018, now the special needs person, provided they possess the proper cognitive testamentary capacity, can also create their own first-party special needs trust, which is a wonderful thing because that option was not available prior to about 2018 until Congress recognized that and changed and amended the law. So once you create that first-party special needs trust, the monies, the inheritance, the lawsuit settlement, or the monies coming to that first-party special needs trust beneficiary can be deposited into that D4A special needs trust. What that will do, folks, that will safe harbor and shelter that money for the benefit of that special needs person, while still allowing them to receive their public benefits, or more specifically, their means-tested public benefits, such as Medicaid or SSI, Social Security benefits. What is SSI? Supplemental Security Income, typically for disabled individuals who are unable to work. And Medicaid here in the Commonwealth of Massachusetts is also known as Mass Health. So whatever state that you're in, your Medicaid state program may be called something more specific, relative referencing your state program. So all well and good. Now the inheritance money or the lawsuit money is sheltered, protected in that first party D4A special needs trust. And the special needs individual can continue to receive their government benefits for their needs-based care, and the monies in that first party special needs trust can be used for things to enhance their quality of life. A couple of big no-nos to watch out for. Money typically cannot be used for shelter or food. Shelter, housing, food. So that money typically will reduce the benefit for the special needs person, and if distributions continuously or persistently are made for those expenditures, it can completely disqualify them from their government benefits. So be careful there. And the biggest downside, in my opinion, of the first party special needs trust is when the special needs person passes away, whatever money is left over in that first party special needs trust is required to be paid back to the government. I'll repeat that, folks. First party special needs trust monies left over are required to be paid back to the government after the first party special needs trust person passes away. All right, moving on, folks. Third party special needs trust, in my opinion, it is a more flexible, more robust, protective trust compared to the first party special needs trust. Why, folks? Because this trust is more pre-planning, and the biggest benefit in my view and opinion is there's no requirement for government payback. I'll repeat that. No requirement for government payback after the special needs person passes away under the third party special needs trust, okay? So when would it be appropriate for someone to create a third party special needs trust? It would be parents with a special needs child. Make sure you work with your estate elder law attorney and create your will in your trust when you're alive and well. And rather than having a distribution made to your special needs child outright in the palm of their hands, you don't want to do that. You want to make sure that your attorney creates a third party special needs trust. Some folks refer to it as a discretionary trust, is another name that you'll hear in the industry as well. But you want to make sure it's a discretionary third party special needs trust where after you're gone, whether it's life insurance, your retirement, or other funds will be payable to the trustee, a third party trustee. It could be another family member, maybe another child of yours or a trusted family member, an aunt or an uncle, who is good with money management that you know, like, and trust unconditionally, that will manage that money for the benefit of that special needs person. This way, the special needs person, after you're gone, can resume receiving their means-tested public benefits for their needs-based care, and the monies in the third-party special needs trust can be used to enhance their quality of life. Again, the big benefit is there is no government payback after that person passes away. And if there's a balance left over in that third-party special needs trust, you can name contingent beneficiaries, maybe your other children or other loved ones in your family who can be the beneficiary of the remaining funds. So there you have it, folks. Difference between a first-party special needs trust and a third-party special needs trust. Hey folks, Patrick Kelleher. If you would like to know more about special needs trust, go on over to elderlawcare.com and click on some of the tabs, the blogs, and the videos there, because you will learn a whole lot more the difference between a first-party special needs trust and a third-party special needs trust. And I did a nifty article here in the South Shore Senior newspaper in the August 2021 edition right here on page 5, and you can find that on our website, elderlawcare.com, where I break down the difference between first-party special needs trust and third-party special needs trust, and then I even get into the community-based pooled trust, which is a D4C trust, which is a little bit different, and I even have a discussion about the ABLE Act, Achieving a Better Life Experience Act, also, which is another planning tool we use for special needs individuals. Hey folks, great seeing you. Next time, we'll see you again on elderlawcare.com.